Welcome back. As you know, my name is Brian Burkhoff, and this is the New Jersey Workers' Compensation Conversation. Today, we'll be talking about death and dependency claims. I'm personally not a fan of working on these cases because regardless of how an individual passed away, it's always a very sad circumstance. But it's very important that we know how to handle these claims properly because the exposure is normally very high. So, I want us to jump right into a factual scenario where you might be handling something similar. Let's assume that the petitioner has a compensable workers' compensation claim where they underwent authorized treatment for a right shoulder tear that needed surgery, and now they've been placed at MMI. We've moved to permanency and both parties have their exams. However, 10 weeks after being placed at MMI and returning to work full duty, the petitioner was on vacation and was involved in a jet ski accident where he sadly passes away. Under these facts, does the petitioner get any workers' compensation benefits? Well, first, let's assume that the petitioner has no dependents whatsoever. If that's the case, what he would be entitled to is simply a $5,000 payment as a contribution towards his funeral expenses under Section 12 of the statute, and he would be entitled to permanency benefits for the amount of time that has accrued in the case. So, in this scenario, the accrued time would be the 10 weeks from MMI to when the petitioner passed away. So the permanency award would not be able to exceed 10 weeks of benefits. Now, if we change the facts of this slightly to say that the petitioner died in the middle of authorized treatment, would they still be entitled to the same benefits? No. He would still be able to get the $5,000 funeral contribution under Section 12. However, it's our position that the petitioner would not be entitled to any permanency benefits, specifically the 10 weeks we talked about earlier. This is because if treatment is ongoing, the petitioner would not have been able to prove any permanent disability. We don't know how the result of treatment would have been. He may have been able to have been back to 100%, in which case there was no permanency at all. So we just refuse to pay anything in that circumstance. But let's change the facts again to say that this man actually had a wife who's considered dependent under Section 13. This actually substantially changes our analysis because not only are they now entitled to the $5,000 funeral contribution, but because they're dependent, they're able to obtain the full permanency award that the petitioner would have had despite his unrelated death. So because we had permanency exams in our first scenario, let's say that the hypothetical settlement would have been 25% of partial total. That equates to 150 weeks of benefits, much more than the 10 weeks that he was able to get previously. So in this case, because he does have a dependent wife, they would be able to obtain the 150 weeks of benefits despite his passing away only 10 weeks after his MMI date. So I want us to move on to a completely different set of facts where petitioner is a delivery driver. Let's say she is on her route and unfortunately is involved in a serious car crash where she passes away on the scene. We're assuming the accident is compensable and that the cause of death is only related to her being involved in the crash. Also, we're going to assume that she has a husband who is considered dependent under Section 13. How do we analyze this claim? Well, first, a lifetime claim could be brought by her estate, and this would be an entitlement to the $5,000 funeral cost. There would be no entitlement to permanency benefits because the death was almost instantaneous. There would have been no period for permanency to accrue. But the real issue that we have to worry about is dependency benefits from the husband. This is where the exposure gets potentially significant. So, if the husband is a statutory dependent under Section 13, he would be entitled to 70% of the wife's average weekly wage for the remainder of his life. Let's say that the wife made $1,000 a week as a delivery driver. That means her dependent husband would get $700 a week. The only caveat to this is if the husband were to remarry. Previously, there was a remarriage penalty that would cut off benefits completely if that was to occur. However, that's no longer the case. So, if the husband were to remarry in this situation, he actually would be entitled to more benefits. There's two different types of scenarios and analysis that we'd have to do to calculate what the amount would be. And I don't want to get into great detail as to what that is because it's particularly challenging, and it would vary based on any set of facts that you would have. So, rather than do that, I'm going to say, please reach out to me individually if you have a situation where a dependent is remarrying and you have to calculate what is owed to finalize the dependency claim. Moving on, I want to discuss how we estimate exposure in dependency claims for reserve purposes, as this is often difficult. In these scenarios, all we can do is estimate. We use life expectancy charts to see how long an individual could live. So, in the scenario of the delivery driver who passes away and the husband receiving $700 a week, we would calculate how many years he has left on an expected basis. If he's expected to live another 40 years, that claim's value is over $1.4 million. But if he's expected to live another 20, it's over $700,000, which is a big difference. So we want to look to set our reserves based on what the expected lifetime of an individual is. Obviously, someone could live to be 100 years old, or they could pass away tomorrow, and this is all subject to change. I want to end by noting how we calculate attorney's fees in dependency claims, because as we're estimating what the total value of the claim might be, it's tough to take a specific percentage of that number. So, rather than estimate, the courts have implemented that the attorney's fee is calculated based on 450 weeks of benefits. So we would use that number to calculate everything. Overall, these cases can be extremely difficult with lots of math involved and factual scenarios that change all of the time. So if you're dealing with a case that you're struggling with, please reach out to me individually and I'll be happy to talk you through it. Overall, these cases, as I mentioned, are difficult for us, difficult for you, and most of all for the families. So we want to make sure that they're handled properly and efficiently. Thank you so much for tuning into our conversation, and I look forward to talking again soon.